Welcome everyone. We're just conscious of time. We'll get started because we've actually got a bunch of people joining us online live stream today. So we don't want to keep them waiting on a Friday afternoon. But yeah, thanks everybody for coming. If I haven't met you, I think I've said hello at least to most people. I'm Amanda Tolson, so I'm the director who heads up the property and business transactions team here. And we've got Carly Brailak, special counsel, here today. I'm especially grateful Carly's in the team at the moment with what we're talking about today. It's great to have another sort of experienced property lawyer to be bouncing these things off at the moment, because it's a bit of a brave new world for us, what we're talking about. But yeah, thank you to everyone who's joining us. And as I said, we've got sort of 60 people signed up for the live stream today, which, as I said, not bragging, but it's the most we've had at any presentation in the firm. So I'll be rubbing that in. So yeah, just wanted to let you know it is being live streamed and recorded and might be used in future for educational and promotional purposes. So just, if you're asking any dodgy questions, so you know that. We're going to try, hi, how are you going? We'll try and keep any questions till the end if that's okay. The people on the live stream are going to be able to send through questions as well, and we'll just make sure we've got enough time. And yeah, so on the live stream, if you could put your questions through on the Q&A, we'll look at those at the end. And yeah, we're here just to make sure you're all in the right place. We're here to talk about the new Property Law Act that commences on the 1st of August. Again, not bragging, but Carly and I had 2 sold-out sessions last year about this. I think a couple of you might have been here, so we are going to cover some of the same material, but we have, there's sort of obviously been some changes and updates, particularly in how that's going to look practically, that we wanted to do today. Yeah, so we're going to try and touch on it, on what we think is most relevant, I guess, for non-lawyers, but look, it's more than 200 pages of legislation. There's a lot in there, so we're not really going to be able to cover everything in detail, but we'll try and be done by 4:15 at the latest today. So we've got time for questions, and then everyone also gets an early mark on Friday, because we know that that's what will make you guys like us and come here again, or join us for a drink outside if you don't want to go home. And yeah, I've got some curly questions at the end. Carly and I actually both sat in on a live stream presentation this morning that was hosted by the Queensland Law Society. Professor Sharon Christensen spoke. I don't know if any of you know us, but Carly and I are fangirls for Professor Sharon. She's actually consulted on the legislation and the new REIQ contracts. She is like the guru of property law in Queensland. She writes the textbooks. She's amazing. She's probably on my invite to dinner list, to be honest. So she spoke this morning, so that was really good. So I've got some insights from her and the CEO of the REIQ as well, which was a really interesting mix when most of the room is full of lawyers. And then there was the CEO of the REIQ as well, talking about how the REIQ see this playing out, and there was, a few tensions there anyway. And so, yeah, we'll touch on some of that as we go through today. But of course, wouldn't be a presentation by lawyers without a disclaimer. Carly can get it to work. So, yeah, it's for information purposes. It's not legal advice, but please come to us for legal advice when this all kicks off. And, yeah, what we're going to cover today, as I said, high level, but we'll start with the seller disclosure scheme, which is probably what most of you are most interested about, and it's definitely been getting, I guess, the most airtime. What we're going to see with the new contracts. Then somewhere in the middle there, we'll cover some of the more boring bits, but particularly I know some of you are involved in leasing. Those parts are particularly relevant to you. And yeah, at the end, we've touching on some things that we think people should start thinking about to be ready for the changes. So the new legislation, as I said, there's the Act, and the regulation has the detail, sort of the finicky things about what's in the new disclosure statement. And as I said, we need to remember it's a wholesale replacement of our previous Act that's been in since 1974. So it's kind of a big deal. It's a huge change. It also explains, I think, why lots of members in our team have been buying lottery tickets, because we're all hoping that we win the lotto and, like Joanne, get to retire before this actually comes in. So we'll see how we go with that. But I'm going to hand over to Carly now. She's actually going to run through the statutory disclosure scheme in a bit more detail.
Okay, so as Amanda said, the new statutory disclosure scheme is really what has got people excited. So it's only 17 pages of 224 pages of legislation, but it's probably the thing that's going to have the greatest impact for anyone that's involved in property in Queensland. So as we've noted, the Act commences on the 1st of August. we'll touch on later, it's very much is a in and out. There's very few transitional provisions that would allow contracts to hang over one way or the other. So from the 1st of August, you start to comply and that's it. If you're signing contracts on the 31st of July, you do it under the current regime. The reason that people are getting so excited is it's really turning the way that we do property law on its head. So until now, we've had what's known largely as the buyer beware kind of system. And that is where it's the buyer's responsibility to find out if there's any issues with the property. And there's been only a few really obligations on the seller to disclose things with the property. The exceptions where that currently the seller has to disclose are things like off the plan sales and body corporate and community title sales. And there's some sort of other bits and pieces. So for example, contaminated land, neighbourhood disputes. So there's sort of a smattering across various bits of legislation. But now what's going to happen is the seller's going to be required to give certain information to the buyer before the buyer signs the contract. That information is going to be a disclosure statement in an approved form and certain documents that are...
So it's in your pack, but just so, again, I think it's really good if we, you flick through it and start, because we're going to be using it a lot, especially you, Damien and Louise. It's going to be great.
And then there's going to be documents that need to be provided to the buyer as well. And in the legislation, those documents are known as prescribed certificates. So currently in a contract, buyers will do all of the searches. And so the buyer can do those searches before or after they enter into a contract. If they do the searches after they enter into the contract, they can really only have a right of termination or compensation if there's something seriously wrong with the property or the seller's title to it. So this is changing it all around a bit because the seller's providing certain bits of disclosure, and then the buyer will have rights if the disclosure is not given or if it's given in a defective manner, if it's, for example, if it's inaccurate. So as Amanda mentioned, a lot of the detail is in that regulation. So the Act pretty much says you need to provide a disclosure statement. Here's how you can provide it. And the regulation says here's what goes in it. The disclosure will have effectively 3 components. 1 is the disclosure statement, 2 is the documents, and then there's also particular warnings that need to be given to the buyer at the same or in the same disclosure. If you use the disclosure statement like you need to, that actually contains the warning statements, and they're scattered through the disclosure statement in various places. We originally thought that that might have been a bit confusing rather than having all of the warnings stuck together. But Sharon Christensen this morning was saying that the reason they've done that is they've put the warnings close to the bits of information that the warnings relate to, and so they're a bit more contextual. So when you're looking at the disclosure statement, you'll see them all sort of scattered throughout.
And if Professor Sharon says that, Professor Sharon's right. I also think, like you see lots of warning statements. I think it was all on the front page. To be honest, I think everyone just flick it and then read the actual stuff throughout. Like I just think you go, oh, that's standard guff. I'll get to the rest. So I think they're trying, again, to force people to actually have to read through it. But again, whether people do or not, hard to say.
So the disclosure statement has to include the information that's prescribed, obviously. Key is that it must be true at the time that it's given, and it must be signed by the seller or their authorised agent. So we'll now look at a few bits and pieces of the form, and one of the sessions that we went to, they said that there might actually be a few different changes to the form between now and the 1st of August as well. So
don't study it too hard.
Yeah.
Look at it, but don't study it too hard.
They're only going to be minor.
Yeah.
But yeah, always use, and here's a tip, always use the current form off the government website. Don't have a saved version on your computer in case there have been changes, and then you're giving it an outdated form, and that's going to be ineffectual disclosure and will give the buyer rights of termination. So this is just from the front page of the disclosure statement. And I'll put this up here because you can see a couple of the warnings in the way that they're given. They say that they're warnings, they're in grey, so they're prominent. This slide also tells you what the buyer isn't getting. And it actually includes some really useful information that the buyer isn't getting, such as flooding information, structural soundness, building approvals, whether there's asbestos in the building. All of those things would be great for a buyer to know, but they're not included in the disclosure statement.
So I think at the start, agents were hoping like, oh, this will do away with due diligence clauses. And we still think it's not going to, because there's stuff not covered. And then we'll get to later about our lack of trust in whether the statements are going to be accurate or not.
Not that we're like, you know, pessimists or negative or anything like that, no. So here's another bit from part 2. You can see from here the disclosure statement. If you actually follow it through, it will prompt you about what documents you might need to consider attaching. So a title search, yes, you know, the seller gives or has given the buyer the following: title search, copy of the plan. They're 2 of the documents or prescribed certificates that need to be given. This next one is an unregistered encumbrances section from the disclosure statement. In the regulation, it says if there are unregistered encumbrances, you need to give details of those. Details is defined. So depending on what that unregistered encumbrance is, will depend on what details you need to provide about that encumbrance. So for example, that walks you through an unregistered lease. That's a pretty common one. Start and end date, the bond, whether there's an option to renew. If there is an unregistered lease, you also need to provide a copy of that. Other unregistered agreement or encumbrances might be an agreement with the neighbour about whether you share a driveway or not, and you haven't formalised that in an easement. You had a couple, Mandy, shared bore agreements.
Yeah, so sort of more rural matters. There's often, shared bore agreements, maybe even compensation agreements or an exclusivity agreement you've signed with a wind company or gas companies. Those sorts of things need to go in here. But of course, see at the top it says, you know, not registered that will continue to affect. So again, if you have some deal with someone who's adjusting cattle, but that's not going to continue after settlement, you don't have to disclose it. So that's the way that it is, you know, at the moment when you do a contract. Well, there's a mortgage on there, but I'm going to release the mortgage. It's the same concept with here. If you have an arrangement, but it's not continuing after settlement, it doesn't get disclosed here to the buyer.
Yeah, which makes sense because it's not going to affect the buyer. So you're thinking about things that are going to affect the buyer and you're disclosing those. So I guess that is one of the examples of things that aren't discoverable by a search of a public register. So when we're thinking about putting together these disclosure statements, it's not just a matter of doing a bunch of searches on a property and then putting that information in the disclosure statement. You're actually going to have to sit down, for the agents and lawyers in the room, you're actually going to have to sit down with your landlord, owner, seller clients and say to them, are there any agreements or unregistered encumbrances affecting the property? And they say, oh, what's an unregistered encumbrance? You need to be able to tell them that so they can give you the right information. So if you don't know what an unregistered encumbrance is, you need to either find out or send them elsewhere where they can find out and get that information so that their disclosure statement is accurate. This one again shows the warnings scattered through. This one warns the buyer that the buyer may not have any rights under the contract if the use of the property isn't lawful under the current town planning scheme. And I think that warning gives us a bit of a clue about what might be in the contract when it finally gets released. Currently, the buyer can terminate the contract if the present use described in the contract isn't lawful. This warning suggests that maybe that won't be the case in the new contracts when we get them.
The anticipation's just so exciting.
Yeah, look, I'm on tenterhooks. I just can't wait. There's also a typo on this page, so that might be one of the changes that they're going to make to the form before
pop quiz.
Yeah, can anyone see it?
This is why we keep Carly around. Good one, Carly.
And then again, this is another example of if you've answered yes to this question, you have to give a copy of that notice to the buyer, and that's one of your prescribed certificates. So the way that the statement works and the obligations work is that if something isn't affected, so if you'd clicked no, you wouldn't have to attach, or it's not attach, you wouldn't have to provide any documents to the buyer about that matter. And this is why we think that it's not going to save the buyer a lot of money, because if the buyer says, no, it's not affected by any of these. Sorry, if the seller, sorry, thank you. If the seller says it's not affected by any of these proposals, they don't give you a copy of the prescribed certificate. The only way a buyer is going to know if that's accurate is if they go and do their own search. So there's going to be some doubling up of searches. There's going to be doubling up of costs, and this is why we think it's not going to save the buyers an awful lot.
Because at the moment, the contract, there's a positive warranty from a seller that, again, most sellers don't realise they're giving that promise when they sign the contract that says the property is not affected. The buyer does the search, and then if you find something, you go, hang on, you were wrong, and now I'm going to exercise my contractual rights. Here, they're kind of giving you a statement, a more positive statement. So if there are problems and this is accurately given, a buyer will know up front. But as I said, it was like there was an implied promise that, lots of sellers didn't really know they were giving when they signed a contract, but now it's just sort of front loading it. But as I said, you need to check. If it says no, we're going to tell our buyer clients, well, your right to terminate because this is incorrect will only arise if we know it's incorrect. And the only way we can find that out is to go and do the search anyway. So
there's a situation where Transport may know issue some advice that a part of the property may be affected by a future construction scheme. It doesn't quite cover that, does it?
And notice of intention to resume. Yeah, I don't think that would be at that level, but it's a proposal as well.
Infrastructure
proposal. Yeah. And it's resolution or adoption of an official process. So it just depends whether it's got to that threshold. And I mean, we've had clients where we talk to where there's something going on, like, the inland rail has been floating around and they still haven't finalised their route anyway. People say, oh, do I have to tell the buyer about that? So it's got to get to a certain threshold. But again, we would always say tell them. They probably know anyway, unless they're from out of the area with an example like that.
And this is the very exciting signing page. And I put it up here because it is important, because it's an essential element of an effective disclosure statement that it be signed by or on behalf of the seller. The people that can sign on behalf of the seller are an authorised agent of the seller. So that could be a real estate agent, it could be a solicitor, it could be Joe Blow from down the road, but you need to be able to prove that that person was authorised to sign it. The authorisation doesn't need to be in writing, but obviously for evidentiary purposes, if it's ever challenged, it's a great idea to actually have that in writing so you can produce that at a later date if it's ever questioned. It also has a space for signing by the buyer. There's no requirement in the legislation or the regulation for the buyer to sign. Every now and again, and that's the current state of play as well, every now and again I get a smarty pants lawyer on the other side of a matter tell me that their buyer client doesn't need to sign. They're right.
We always about the BCCM disclosure there.
Yes.
Yeah. Yep. Under the Body Corporate legislation, there's this disclosure that's issued at the moment that, again, everyone.
And Land Sales Act.
Yeah, and Land Sales Act. Most people, the buyer does sign them. I think, when people, it says I'll sign it, but it's not actually required, but it helps the seller be able to prove that they did give it to them, particularly if the date there, if you have a date and it's earlier, like the day before the date the contract's signed, that would be ideal in this situation.
Yes, every now and again we do get disclosure statements that are dated by the buyer after the contract date because they don't realise even now that the Body Corporate and Community Management Act requires the seller to sign it before it's given to the buyer. So typically the way that the contract signing will work is that the seller will give the contract and the signed disclosure statement to the buyer. The buyer will then sign the contract and the disclosure statement and return it to the seller. The seller signs the contract as the last step of all. We still find some people that give blank disclosure statements to the buyer in the first instance. The buyer signs both documents, sends it back to the seller signs both documents. And if that happens, then the buyer's got a right to terminate at any time up until settlement. So it's really important that the seller signs the disclosure statement before it's given to the buyer.
And in that case, though, the seller couldn't terminate. So let's say you've stuffed up, you don't have a right to exit and fix it. you're just on the hook and you have to wait and see what happens. So we really don't want to do that.
No, not ideal. So this slide shows the documents or certificates that have to be provided. As you've seen in the snips of the disclosure statement in the slides, in the full copies of the approved form of disclosure statement that have been provided, there are prompts for the seller to consider whether any of these documents need to be given. The seller might have some of these things in their possession already. So you would expect notices issued by the local government under the Building Act or the Planning Act, if they've received any notices under the Environmental Protection Act, anything like that. The title search, registered plan, community management statement, they're all really quick to get. We can sit at our computer and we can order them and have them back in a matter of minutes usually. The things that are going to take time for the seller to put together are the body corporate certificates, whether it's BUGTAR or BCCM. And potentially if the seller doesn't know or they'd like to do searches about notices of intention to resume, and if they want to do any searches of the local authority, if they're not sure that they've received any notices under the Building Act or the Planning Act, those searches can take up to 2 weeks. So our recommendation is going to be that these disclosure statements are prepared at the time that a property is listed for sale, because if you have a buyer turn up on day one and they want to sign up, you don't want to say to them, oh, can you hang on a couple of weeks while we organise our disclosure statement? And then that runs up against the risk potentially of a disclosure statement not being accurate at the time it's given. So if you've prepared your disclosure statement before you've listed, it's taken 3 months to get a buyer, the seller needs to make an assessment of whether they want to reorder those searches, because if anything has changed, then that disclosure statement that was done 3 months ago might be inaccurate and hence ineffective.
Although they were talking this morning, you know, you have to put the rates and water information in the certificate, and a small change in the amounts of those is not going to make the statement ineffectual, because that's the obvious one that, you know, especially if it's quarterly, that's going to change. So that shouldn't be too much of a problem. And I guess the rest, most engaged buyers should know, oh yes, I'm involved with the body corporate, I haven't received a notice as an owner that they've registered a new community management statement, or those sorts of things. But again, we as buyers, lawyers, will get something and all the searches are dated 3 months ago, 4 months ago. We'll go, they obviously think they're still accurate, but again, we have to do a new title search because we recommend that we should, just in case.
Yeah.
Just right.
Yes. We won't know where that is though.
Oh, sorry, a minute, could we go back? So some of you might remember PAMDA, the Property Agents and Motor Dealers Act, and that had a prescription that there had to be a warning statement that is attached to a contract. There is no obligation whatsoever for the disclosure statement to be attached to anything. There is also no obligation for the documents that you need to give to be attached to the disclosure statement.
And the reason for that is Professor Sharon was around, like Carly and I were in the bad days of PAMDA, where it was like there was a case that said you can't bulldog clip it to the front, it has to be stapled. And so I was a junior lawyer working with Carly in Brisbane, where we had to like make sure that on the photocopier we had a picture of the staple so we could prove we'd stapled it. And so she stayed away from that. I think Sharon has gone, no one wants to go back to those bad old days. These things can even be given separately, she said.
Yes.
You've just got to prove they were all given. She said, obviously, if you've sent them in one email or something, it's easy because you can produce one email and say, here's where I sent the statement and all these certificates. But she said, you know, if you sent them over time and you can prove you have, that's okay. So thanks be to Sharon Christensen for not putting us through the pain that we had with PAMDA, because that was really stressful. And then we only just sort of started then emailing contracts. This was how long it was. And do you remember, Carly, then everyone had a big worry about whether you had to have a locked PDF because that's attached, because then no one could edit.
It had to be an uneditable PDF document.
Like, it was just a nightmare. So anyway, we're not going back there, which is great.
There was questions about whether faxing, if you faxed it, was it attached?
And I think it was in a single fax.
Had to be a single transmission.
Single transmission, you had to have a single transmission.
Contracts, you'd watch it going through the fax machine, have to check that the right number of pages went through. Yeah.
Good times.
We don't want to go back. We're still a bit scarred, as you might be able to tell. So as with any rule, there are exceptions. We think that Two of the exceptions require the buyer's consent in order for them to apply. One is where all of the parties to the sale are related parties. And then the other one is where the purchase price, including GST, exceeds $10 million. So if the buyer waives the requirement for the disclosure statement to be given in those two cases only, then you don't have to comply. Other examples are boundary adjustments and realignments, transactions where the local government or a state or federal government or listed corporations are involved, proposed lots. This doesn't apply to off the plan. Makes sense because the property is necessarily going to change in character between when you issue your off the plan contract to what's actually delivered at the end of the day. Transfers pursuant to a will, and also any leasehold land under the Land Act doesn't have to comply. Now, one question that got asked today that actually stumped the guru a bit was, those of you who practice in this space will be familiar with options and off the plan contracts. So you have an option. One of your conditions in your option is the reconfiguration of the parent lot to create the lot that's ultimately going to be sold. At the time you enter into your option, you don't need to comply because it's a proposed lot. But then by the time you enter into your sale contract, it will be a lot to which the disclosure regime applies. Her initial response was, I don't think it will apply, but then she also said, leave it with me. So
Yeah.
they
It was
haven't
really
quite
clear if
numbed
there's
that
a
out.
nominee, if there's a nominee and the
Yes.
buyer changes, you have to do a new disclosure.
Yeah.
Because, or, you know, and even with normal lot, if it's not off the plan, you have to
Yes.
redisclose because the party's changed.
Yep.
So that's going to be a pain for us in option nominee.
So if you have an option, the disclosure regime applies to options. It applies to auction contracts, options, private treaty, commercial, residential. It's really broad. So these are literally the only transactions that it doesn't apply to. So where you have an option to purchase, the disclosure has to be given before you enter into the option. It is an exception to this if the parties are the same at the other end and disclosure was given before the option was entered into, you don't need to re-give it. If there's a nominee, you need to re-give it. If you enter into your option pre-1 August, so you're not obliged to give it, but then your option is exercised afterwards, you haven't given disclosure before the option, so you need to give it before you enter into the contract. So
Great.
It's heaps of fun. It's going to be great.
We might
The
keep
other
moving
thing
through.
that they didn't really have an answer for when I asked the question at a previous seminar was, those of you who plan the commercial property sandpit will know that whenever you have a purchase, say $10 million, including GST, just say the buyer has waived their right to a disclosure, so you haven't given it. What happens if they do their due diligence and you do a renegotiation and all of a sudden your purchase price is down at 9 million? Again, the answer was, oh, we don't think you'll have to give it, but leave it with us. So we're waiting. The QLS is going to issue a frequently asked questions document that they're going to continue updating, where they're going to let us know what they think about all of these curly questions that they're getting in their seminars that they're delivering. So termination, what happens if we get it wrong? So there's a couple of different scenarios. If we don't give a disclosure statement at all, the buyer can terminate at any time up until settlement. If we give a disclosure statement, but we don't give a prescribed certificate, the buyer will have a right of termination.
Without any penalty.
Yep, without any penalty. They just get their money back, walk away.
And there's no right to compensation either. So it's just a termination right. They can't then sue the seller and say, you didn't disclose properly and you wasted my time. It's just a termination right.
Yeah. If you give a disclosure statement and it's inaccurate or incomplete in relation to a material matter, so Amanda said earlier, rates and water aren't material matters, so you can't have a right of, or any rights if that changes. But if it's in a relation to a matter other than that, and at the time the contract was signed, the buyer didn't know the true state of affairs, And had the buyer known the true state of affairs when they signed the contract, or at the time of signing the contract, they wouldn't have signed the contract, then the buyer can terminate. So it's a lot less clear, it's very muddy waters, it's very subjective, and I can see a lot of opportunity for litigation on whether a buyer has terminated, has had a right of termination, where the seller might allege that they would have entered into the contract anyway, or they did know the true state of affairs at the time they signed the contract. So I reckon my colleagues in the dark arts of litigation down the hall would be thinking this drafting is great, because I can just see this as being the new frontier of litigation on the Property Law Act. Another really fun thing about terminating the contract is that where the disclosure that you've missed should have been given under another piece of legislation. So, for example, if you don't give a contaminated land notice under the Environmental Protection Act, or you don't give a copy of a tree order, or if you don't give notice that there's a neighbourhood dispute, and that other legislation gives the buyer rights of termination, like those ones do, then you don't terminate under the Property Law Act, you terminate under that other legislation. And I can see a lot of people getting this wrong, like a lot of lawyers getting this wrong, slash conveyancers, because if you give a notice saying, I'm terminating under the Property Law Act, you actually don't have that right, and you've repudiated the contract by terminating where you didn't have the right to terminate, or using grounds that you didn't have to terminate. So it's going to be a bit tricky for people to remember to say, oh, you didn't give me a contaminated land notice, I'm going to terminate under the Environmental Protection Act and not the Property Law Act. So that's a bit of a technical, lawyer, nerdy point, but again, I think it's something that people are going to get wrong.
It'll explain why Carly and I probably look 10 years older if you like come in another year with this nightmare.
And yes, apart from those two exceptions, the parties cannot contract out of the legislation or the disclosure regime.
We have lots of clients who are used to doing good deals. They're like, I'm big and ugly enough to look after myself. I don't need this, like all the time. It doesn't matter. Unless you're in one of those exceptions, you absolutely have to do it. And if a buyer convinces a seller, don't give it to me, I don't want it, they're still going to have that up their sleeve to terminate. So, yeah, unless it's an exception, don't do it.
Yeah.
All right. Oh, hang on.
You can take over.
Yes. Hang on. Gone too far. All right, what can we see going wrong, or where to from here? Oh, my goodness. Carly, you're in charge.
Oh, God.
Yeah, gone too far. All right, so
How
what's
unusual.
coming? Yeah, so there's going to be big changes to the standard REIQ contracts. Professor Sharon promised us the residential one's coming next week. So again, people in the game, we're just really stressed because, you know, they're going 1 August, you have to use a new document and we don't even know what it looks like. There's only going to be 2 contracts now. So at the moment, there's 4 separate body corporate contracts. There's just going to be 1 resi and 1 commercial. And then within there, you select and put in further information depending on whether it's in a body corporate or not. Sellers are going to have to be more organised, and unfortunately the agents in the room, that's going to fall to you to have to deliver them the bad news. I mean, at the moment, you know, we all know people can make a decision like that. You do a title search, you whack out a contract, woof, we're underway. It's going to take a lot longer than that. People are going to get annoyed, but it is what it is. Otherwise, again, you're going to have a false assurance of, oh, look, I've got this lovely contract, but you haven't done what you need to do, so the buyer can terminate. So yeah, as we said before, you know, when you're talking to an agent, you know, the REIQ are saying that, you know, the agents that they're talking to, that's when they're going to put it on the table. But I guess if any of you are selling, and I know a couple of you have said from here, because I'm selling a property, please make sure you tell them, hey, let's do those searches. I want to be ready, you know, so as soon as a buyer comes along, you can sign them up. Yeah, because under the New South Wales Conveyancing Act, there's an obligation to have your contract ready to go before you list. In some ways, I think that would have been a nice thing to have here, because it would have been easy for the agents to point to, instead of saying, I think it's a good idea. You go, it's not me, it's the law, but they didn't put it here. If we have an opportunity, we'll ask our friend, Professor Sharon, why not? But again, it just makes sense. Yeah, so at the moment, we've been waiting to see particularly what the REIQ said about who's going to do it. we didn't know whether the REIQ might take a cautious approach and go, ooh, we don't want to have to describe what, explain what unregistered encumbrances are, make this the lawyer's problem. The REIQ have been very clear that they are putting together processes to support agents in being able to prepare these disclosure statements. The CEO of the REIQ said this morning they want to keep the agent front and centre. Again, we won't be offended about that. But what we understand, InfoTrack's got like a new process where I think you're going to be able to put in property details and sort of click one button, and InfoTrack will do all of the searches you need to complete this. I think Carly's comment was they might have 2 Supermaxis next year in the Sydney to Hobart with all the money they're going to make from setting this up.
Double searches.
Yeah, so again, we just don't know what that's going to look like. The pessimist in me says it's only when it's, again, there's a buyer there, hang on, something's not quite right. Can you guys advise on this really urgently? So no more long lunches for us, not that we take them anyway. But yeah, so I just think it's those sort of logistical issues, I guess, that make you the most anxious because we just don't know how that's going to show up in practice.
The other thing that InfoTrack are doing is in that function where you can work through the disclosure statement for the agents, REIQ and InfoTrack have got an association somehow, and there's actually a button in the InfoTrack screens that say refer to lawyer, and you can put the lawyer's email address in and they'll email the lawyer to jump in and help provide advice on whatever the issue is. So that's one way that, potential to bail out for agents if they sort of start feeling a bit uncomfortable about what they're saying is bordering on legal advice.
Yeah. And I guess conveyancing costs, we've had Queensland Law Society telling us really clearly we need to look at our costs because of the extra work and risk involved in this process where lawyers are involved. As most people in the room would know and those on the live stream, conveyancing costs has been a race to the bottom. I occasionally get an old file or an old bill from a client and people literally paid more 20 years ago than they do now. Some of the conveyancing practices we see, they charge like $600 for a purchase. It's ludicrous. But if you're going to properly do these things, and this is what we say about the way that we approach matters, if you're going to do it properly, you've got to have skilled people spending the right amount of time. So we'll see where those prices go. But again, if I'm a betting woman, it's only going to be up again, because otherwise this is another thing where the finger just gets pointed saying you didn't do all of this on top of then advising on the contract as well. Trained pessimist again, what's going to go wrong? You have to get consent to send it electronically, the disclosure statement to the buyer electronically. We don't really know what that means. Yeah, Professor Sharon said today it can be implied if they say email it to me, but you've got to have some evidence, like that they said that. So we'll see how that goes.
There's also different rules in terms of when the disclosure statement is deemed to have been received, depending on how it's given. So if you give it to an email address nominated by the buyer, it's deemed to have been received sooner than if you just send it to an email address that you think is the buyer's, or they have to have actually retrieved it rather than it being capable of being retrieved. Like
it sounds like you need IT evidence unless the buyer replies and says like, got it, or they sign it. So again, I think people are going to default towards making sure the buyer signs it because that's clear evidence that they received it, even though it's not technically required. So increased costs for sellers in paying for these searches. There won't be decreased costs in buyers in search fees is the reality. Because as I said, we have to do a search to make sure that if they say there's no problem, that there actually is nothing. We were talking about stale disclosure statements. So at what point will it be too old? And as I said, I think that's just a matter of understanding and being able to explain to a seller, if you know that there's any change in these things, we need to update it. I said rates and water amounts, you don't need to worry about too much. But yeah, it's just going to be hard to know, and they have to actually engage their brain. But yeah, there's nothing in the legislation that says as long as, the searches are dated within 3 months, that's acceptable. It's not like that. It just has to be accurate when it's given.
And once it is given, there's no obligation on the seller to update it after that point. So it doesn't matter what happens after you give the disclosure statement. As long as it's accurate at the time it was given, box tick.
Yeah, unless the contract has ongoing warranties up to
Oh.
completion, which we don't know about yet because we don't
Yes.
have the contract. But yeah, we'll wait and see. So again, we just don't know how these things are going to fit together. But that's all we're going to say at this point about the disclosure statements. Carly, I was going to talk now just quickly, I'm just going to try and go through these other extra bits. As we said, that's, what did you say, Carly? 14 pages of the legislation is about
17.
17, sorry, thank you. The rest is this other stuff. So extensions of time for settlement. This is putting in the legislation what we have in REIQ contracts at the moment, which is basically giving everybody, for example, the extra time to settle. Next business day, if someone puts a date, like a settlement date that's on the weekend, the REIQ contract says it goes over, but if you've got a land settlement that someone's done on their own contract and it doesn't have that in it, this will be in the, this will actually be in the legislation to give you that right. And yeah, so adverse weather events as well. So again, this is going to make our life a little bit easier in being able to presume these things, even if there's a different form of contract used. Leases, again, this sounds, a little bit boring, but it basically clarifies that, yeah, at the moment, not all clauses in leases that are not registered run with the land. This makes sure, this is basically saying that even if it's a personal right within a lease, it will pass to somebody who is the buyer of the land or the assignee. So just
Unless it's specifically excluded. So an example might be if there's an option to purchase the property, that might not necessarily run to any assignee of the lease. This will mean that it does, unless it's specifically excluded at the time the lease is signed.
Yeah, as I said, for most people, this is how people look at leases anyway. They sort of think, oh, well, I'm the new landlord, I have to comply with everything in the lease. So this is putting that in place at law, even though it actually wasn't there before. Landlord consent, this is an interesting one to see how this is going to play out. So at the moment, if a tenant has to go to a landlord for consent, they want to assign the lease, to a business buyer, if they want to sublease, if they want to change the permitted use or make alterations, there's a process in the lease which says how the tenant has to go about getting the landlord's consent. This is putting in place a legislative overlay on that, which says a landlord cannot unreasonably withhold consent. They have to reply within 1 month. They have to determine it within 1 month. And then the tenant can go to court if they have a problem with the decision. So, at the moment, the leases might say that, the landlord basically can act unreasonably and, they can ask for as much extra security or bank guarantees from a new tenant as they like. Otherwise, they can withhold consent. This is going to put restrictions on landlords around that. I've got some commercial landlords who are going to be unhappy with that because they think, well, I gave, that position to this tenant because I know them and they've been my tenant for 20 years, and then they go and sell to some person I've never met, and I've got to act reasonably in what, and I just want to say no. The only way they can say no is to have an absolute prohibition on assignment in the lease. Now, of course, they can always vary that position if a tenant comes to them, but if there is any ability for the tenant to assign the lease in particular in the lease, then this applies. They can't act unreasonably and they've got to respond within a month. If you're a managing agent, I think just bear this in mind, and then we'll...
It's not just assignments either.
Yeah.
It's changing permitted use, granting a mortgage, making alterations. So yeah, it's broader than just the assignment piece, but the assignment is definitely going to be the most common one that we come up against.
And this is a funny one, but at the moment, if you transfer, you're a tenant, you sell your business and you transfer the lease to the new person, you can remain liable for them not paying the rent, and that can continue down the chain. So a business could, at the moment, change hands multiple times, and unless a tenant knows and is properly advised to get themselves released and the landlord agrees, there can be a chain of people that are liable if the end tenant goes broke. At the moment, this basically cuts it off after the first step, so you can't be liable for the next person you've never met that goes broke. Which again, people go, oh my God, I can't believe that ever happened. And I was only talking to another lawyer the other day saying, oh, I've never acted for somebody, and I think Carly's never seen this happen. And he said, oh, I was talking to an insolvency practitioner and they do it all the time. So it has been happening. So as I said, Yeah, between Carly and I and this other guy I was talking to, we've probably got too many decades of practice between us. As I said, evil lawyers, we haven't done it. Most of my landlord clients would feel pretty bad going after someone that far back. But he said, yeah, insolvency practitioners apparently don't feel too bad. But yeah, this doesn't change the Retail Shop Leases Act, if anybody's familiar with that. That requires a release in certain circumstances. Oh yeah, and there's new forms under the Act. So there's a new notice of default under an instalment contract, which doesn't really get used much. Notice to remedy breach. Thank goodness the old one looked like it was from 1974, so that's good.
It was.
Yes, I don't think they had updated it at all in that time. A breach notice and then a notice to terminate as well, because there's never been a standard form notice to terminate a lease.
You don't have to use that.
Oh, yep, that's right.
That's optional. What have we got here? It's not required to be in the approved form, but any notice of termination has to identify the land subject to the lease. The party giving the notice, state that the party giving the notice is terminating on a particular day, and it must be signed by the party giving the notice. So if you use that form and follow it, then you'll have ticked those boxes, but you can freestyle if you want.
I feel like it's going to add a bit more formality to the notice as well, because I think, we normally sort of write a letter and I'm sure people go, this might make it look like it's definitely a notice to terminate. Easements. So this is a bit like the lease situation I was talking about before. Positive covenants in easements have not been enforceable against successors in title down the road. This is just making sure that all obligations do carry on. Again, I think everybody has presumed all terms in an easement do carry on. So that's all in there. I'm just conscious of time. I'm definitely over where I thought we'd be, Carly. This is a bit, we just wanted to see, our suggestions, I guess, of are you ready? If you ask me that question, I think the answer is no. I feel like we have absorbed as much material as we can, but again, we don't have new contracts yet. It just still feels all a bit scary. But yeah, I get familiarise yourself with it. Carly and I both big nerds have the Act printed on our desk in case we have some spare time. But yeah, if you're a property owner and you might have received these notices and you think you're going to sell, dig them out, make sure you know where they are. Agents, developers, landlords, really have a look at that disclosure statement. Have a think about, if you're a business owner, what's your position and in terms of what you're going to do, and if you need help, when you're going to call that in. Budget for high transaction costs for conveyancing. Sorry. I promise we did not ask for this legislation to come in. It's not to feather our own nests. Keep an eye out for REIQ contracts. So as I said, they said residential next week, the commercial a couple of weeks after that. So they're giving us all of, maybe a month, 3 weeks to get used to them before we have to use them. If you're a landlord, make sure you're across these landlord consent. If you're in a small body corporate, make sure your records are kept. Like if you're in a small lot scheme and you go, oh, we've all lived here for ages or all had an investment property here and we know, if things aren't up to scratch. We see a lot of the standard 2-lot modules at the moment that don't comply with the legislation. So they don't do all the things they're supposed to, like have meetings and put
Keep
money
records.
in, sinking funds, records, all these sorts of things. You can convert those to the specified 2-lot scheme, so you don't have to do those things. But otherwise, when it comes to disclosure, you're supposed to have those things. Yep. Although Carly and I were talking about it, and there is the ability that when you go to the body corporate and they say, there's no committee, we don't do anything, you can basically put that in your disclosure statement to say the body corporate effectively doesn't exist, they don't meet, they don't have anything, and that's going to be enough, provided you describe it that way. That's going to be enough for to comply with the disclosure requirements. And then we're up to curly questions, Carly.
Yep.
So we just want to talk about this drop dead date. If you prepare a contract on 31 July and everyone doesn't sign it, you've wasted your time. You've got to use a new contract the next day. You can't issue a disclosure statement on 31 July thinking, oh, no one will sign it. I'll be really organised and use the new format. It's not an approved form until the 1st of August. So, they're not allowing us to be organised. You've just got to use one form and the next day it's the new regime. You can give the disclosure statement certificates at different times. What was the other one? Oh, how can you email them? They said, you can email with attachments, or you can email with a link, but then if you're put to proof, you have to be able to prove the link was active and able to be accessed at the time the link was sent to the buyer. I'm no IT guru,
For a
but
reasonable period thereafter.
yeah, so I don't know how you're going to prove that. I think personally I'd prefer an email with PDF attachments that you can have, but if you're emailing a lot of stuff, that may not be possible. Any other questions from the floor, or I think we've also got.
We don't have any questions on the live stream at the moment.
Anyone have any questions? Here we go, Peter.
If you have a contract,
Hmm.
so look into one of this. If you have a contract that falls over,
Hmm.
and then you then enter into a new contract, do you have to reissue the disclosure statement or can you use the original one if the circumstances haven't changed?
Yeah, so the question for our live stream, so Peter, you've got a buyer in the middle of August, you issue them the disclosure statement, they pull out under finance. You can use that same disclosure statement with a new buyer as long as you form the view that it's still accurate. So yeah, you can, but you'll just have to go through. And again, I think it might make some buyers nervous if it's too long. If it was, 8 months and you've got an 8-month-old title search, I don't know, the agents in the room can tell me, but if people actually engage in the detail of it, I think they might go, oh, I don't know about this. It doesn't look very organised. Some of them you might be better off redoing them. But yeah, as I said, if it's a property you're going to know you haven't got any notices under the Building Act or, anything like that in that time. Yeah. So as long as it's accurate when it's given. Yeah. Yep. I've got some spare questions, would you believe, up our sleeve on the next one. So you've got a bidder, so it applies at auctions. You've got a bidder who's not registered at the start of the auction. How do you disclose to them? Carly.
You have to have it displayed at the auction, so everyone can see it.
So registered bidders you can send to them before.
Yes.
Obviously. But yeah, I imagine at every auction there's going to be it all on display. So yeah, then if somebody comes in at the last minute. And Carly, what if you don't know whether it's going to be, if it's 9 million, maybe really hopeful it's going to go for 11 million. What do?
You do a disclosure.
Yeah.
Just in case.
Yep. So,
and also because you have to get the buyer's consent.
So auction you'll have to disclose anyway.
Yes.
Unless you get every registered bidder to consent, you could probably do that. But again, an unregistered bidder can't consent. So, what if you've got multiple sellers? Does everyone have to sign the statement? Carly?
Yes. Yeah. Unless they all appoint the one person to sign as the authorised agent.
Yep. And again, you'd want evidence of that authority. But yeah, with multiple buyers, it says you only have to send to one of them.
Yes.
Go figure.
Yeah,
I think that's a bit weird. Multiple lots. Does anyone do a bit of rural? I hadn't thought about this until I heard, like I was listening today. A separate form will be required for every lot if there's any difference in the information you're given. So, sometimes you've got farms and there might be 4 lots, but they're rated together and, they're sort of treated as the same one. But, sometimes you've got a farm that's a little bit of a hodgepodge. There's different rates. So when you go to put the rates information in that form too, you're going to have 2 lots of information. If there's any difference in the information, like one lot's on the Environmental Management Register and the other one's not, you'll need 2 different statements. So it's very clear this lot's on the Environmental Management Register and this one's not. So I do a bit of work in the rural space and I went, goodness, that is going to be a pain.
And the amount of documents you'll have to provide if there's multiple lots on multiple titles.
Yeah. And especially at the moment, rural, to be honest, I like doing it because it's the easiest because people who are buying farms are so casual. And again, the standard position under our rural contracts, that we usually use, which is not an REIQ contract, is seller gives no promises. It could be contaminated. It probably is. I've probably had livestock dips. I don't know. And everyone goes, yeah, we know that's okay. We know how many acres it is and what it's worth an acre. I'm happy with that. It's going to be a whole new world. So look forward to educating my farmer clients when they sell. Any other questions or? Randall? Randall's a lawyer, so this is going to be a hard one.
Is it going to make any difference?
I think if you have a buyer who is represented by not maybe who doesn't have the best representation to give them advice about searches and there is a problem with a property, this puts it in their face. So I think that's good. So if it's on the contaminated land register, at the moment you're supposed to be told as well. This maybe gives you more of a chance because people are going through the statement. What's something on the form, Carly, that you think people will definitely catch that they wouldn't at the moment?
Unregistered encumbrances.
Yeah. There's probably a few things that it might put it more in the buyer's face, but I don't know. Oh, look, we've got colleagues in New South Wales who definitely like the system there, which does have a lot of information. But I think Carly used to practice in New South Wales. It's probably even more in depth than what's here.
I think it's easier in New South Wales because it's just a matter of that. Well, 20 years ago when I practiced in New South Wales, it could have changed since then. There was just a box on the second page of the contract and it just had tick boxes, 2 columns, tick boxes, and you just ticked which things applied to your property and they were the documents that you had to attach. So everyone had to have a certificate from the local authority, so your council certificate. If you had an easement, which was a Section 88B instrument, sort of similar things that are being disclosed, but it wasn't a 8 or 9 page disclosure statement where you're providing information and documents. It's just tick, 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 here's your documents, off you go.
If people read some of the warnings, I think that's good because I don't know about you, Randall, but we still talk to people who have these assumptions about, oh, but a seller, surely they had to tell me about that, or surely there's a house on it, surely the house has to be approved. Well, no. You know, that people just come at it with these assumptions. And if they read that, I think some of the warnings will reverse incorrect assumptions. But again, maybe I have no faith left in humanity. I still don't know whether people are going to read them. As Carly said, it's 8 pages. If they read it. Well, no doubt lawyers will be expected to have a letter where we've given it to our clients saying, make sure you've read that. Yeah, absolutely.
Interestingly, though, if you give the disclosure statement via a link, you don't actually have to worry about whether the buyer has clicked on the link. I guess lead a horse to water, it's their own fault if they don't go and have a look at it.
You just have to prove the link was operational.
Yeah.
So, anyway.
So you can only do so much for people.
And the council here, not so much the elected representatives, that's what he was about. They actually want to, they want to sell off small here. Problem with that, because they need money for funding for that, but it's actually contaminated land. So it would be the same principle applied to them, I presume.
Yeah, that they would have to, sorry, would the council have to disclose that land is contaminated? Yes, except for if they're are they one of the,
Yes, so
no, but are they one of the authorities that's excluded from needing to disclose it all, Carly? It's government. Is it local government as well?
yes.
I had understood they couldn't sell the airport because it has basically a restriction from the state government when it was given.
I think it does apply. The only time that they're not, when they're the buyer, it doesn't apply. When they're selling to recover rates, it doesn't apply.
Yeah.
But otherwise, when they're selling property, yes, it does apply. I mean, for contaminated land, though, they've got that obligation anyway under the Environmental Protection Act. So even if they were the subject of one of the exceptions and didn't have to give a disclosure statement, they'd still have that obligation under the Environmental Protection Act. I can't see any questions from our live stream friends.
We've put them to sleep.
Yeah.
All right. Well, anyway, everyone, if you have any other questions, we're obviously having a drink. Oh, sorry. Yes. Sorry. Yeah. So the question was, why didn't we adopt the New South Wales system? There's probably a good legal answer. I've got a smarty pants one.
Oh, look, go with the smarty pants one.
They never like to do what somebody else has already done because they just want to be smarter and come up with their own clever system. Yeah. 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 So no, I don't know why.
Well, okay, I'll give a serious answer.
Thank you, Carly. There's got to be a grown up in the room.
There was a Property Law Act review that was done by QUT. And so that review actually looked at legislation all over the place and looked at our current practices and where the current risks are and so forth. And that review, which I believe included Professor Sharon,
Yes.
came up with a set of recommendations about how the Property Law Act should be amended. It did go out for consultation. There was plenty of opportunity for everyone to put their 2 cents in. And after all of that process, this is what we've got. And that's what they determined was the best solution for Queensland.
And I think Queensland is basically the last buyer beware jurisdiction, is my understanding, which is why they said we needed some sort of disclosure regime because that was deemed to be pretty backwards. I think it was pretty efficient, but anyway. But yes, why they didn't just grab the New South Wales one and roll it out, I couldn't tell you, unfortunately.
Another scenario is, a few years ago, my parents used was joint owner with my mother. And when she passed away, if I'd sold it within 2 years, I would have had to pay capital gains tax, which is the three parts that I had capital gains tax. The other one is I've got a block of land in Tasmania I bought back in 1984, $6,000. Now worth well over 100,000. I can sell that now to a on the market. Still don't pay capital gains.
Yeah, right. It's a win. Very good.
Still no
All right.
questions here. So
Okay. Thank you, everybody, for coming. We might grab a drink, and if there's any more questions, direct them to Carly. Thank you.
hang on.
Oh,
Well, nothing's changed yet. So yeah.
oh. I don't like
Asking
change,
in
Randall.
July and August. It's giving us a reason to talk to all of you and